Thank you.
Judgment in the appeal in the matter of S. a child.
Should a local authority which brings care proceedings to protect a child from harm have to pay the costs if they fail to get the order that they want? The general principle in civil proceedings is that the loser pays the winner's costs, but that principle does not normally apply in cases about the future of children. These proceedings were brought about 4 children who were suffering significant harm in the care of their mother. The mother's former husband was the father of 2 of those children, but the couple had separated before the younger one was born, and the father had had limited contact with the family after that. During the proceedings, he and his new wife were assessed as carers for 3 of the children, but for a variety of reasons this proposal was rejected. The father then separated from his new wife and acquired a stable, well-paid job with accommodation abroad. He wanted to look after his younger child. The local authority, supported by the children's guardian, considered that he would not be able to meet the child's complex psychological needs and proposed a closed adoption for her. The judge accepted the local authority's case and made an order authorising her placement for adoption. The father appealed. The Court of Appeal held that the judge should have ordered an assessment of the father's ability to look after his daughter and had not properly explained why a closed adoption was the right course to take. The Court of Appeal also ordered the local authority to pay the father's costs. The local authority now appeals to this court against that order, while accepting that this particular father should not suffer financially as a result. The question of principle has rarely arisen in the past because parents are automatically entitled to non-means-tested, non-merits-tested legal aid to defend care proceedings brought against them. But there is a means test for appeals, and this father, although not wealthy, was earning too much to qualify. However, the principles governing the award of costs should be the same, whether or not a party is entitled to legal aid. Orders for costs are not normally made in cases about children because the parties are generally acting in what they believe to be the best interests of the child and should not be deterred from helping the court to reach the right solution by the risk that they might have to pay the other side's costs. The court's task is to do what is best for the child. There are no adult winners and losers. The only winner should be the child. However, orders may be made if a party has acted reprehensibly in relation to the child, or has taken an unreasonable stance in the proceedings, or the child's welfare may be put at risk if a costs order is not made. There is no reason why the same principle should not apply in cases involving local authorities, which have statutory duties to protect children from harm, as apply in cases between parents or other family members. In this case, the local authority had not behaved reprehensibly, nor was it unreasonable for them to seek to uphold the judge's order in the Court of Appeal. It had not been shown that the child's welfare would be put at risk if the father had to pay his own costs. Hence, the appeal is allowed and the costs order set aside, but on the basis that the father will not have to repay the costs that he's already been paid by the local authority. The court is also grateful to his legal team for appearing for him pro bono so that the issues of principle could be properly argued before us. The court is now adjourned.